Ladies and gentlemen, thank you very much for attending this webinar hosted by August Debouzy. It is a real pleasure for me to present why and how a strong European initiative could bring European countries to adopt the best anti-corruption standards in the world and create a global playing field in order to face extraterritorial sanctions imposed by the US. To achieve this goal, the European Union should take the lead to impose every member state to harmonize their anti-corruption law, to strengthen the cooperation between European authorities, and to coordinate the European action on combating corruption through the EU Agency for Criminal Justice Cooperation, nicknamed Eurojust. Historically, it's worthy to recall how the US imposed an extraterritorial application of the anti-corruption legislation. Compliance originated from Anglo-Saxon business law. The first compliance-related text comes from the United States in 1977. The Foreign and Corrupt Practice Act, well known as FCPA, provided criminal sanctions for bribery of foreign public officials by US or non-US companies or persons, including for acts committed abroad and tenuously related to the US territory. For 20 years, the FCPA remained the only anti-bribery text. It consolidated an American conception of justice in compliance law, including carrot and stick policy, a severe but negotiable justice, as well as an economical approach to the rule of law. Under the willing to impose to their trading partners the same constraints, several attempts have been made to extend anti-corruption mechanism to Europe. And on December 17, 1997, OECD members signed the Convention on Combating Robbery of Foreign Public Officials in International Business Transactions, which established legally binding standards to criminalize bribery of foreign public officials. The agreement, which was ratified by 38 countries in 2009, aimed to establish effective, proportionate, and dissuasive criminal sanctions against their nationals who bribe a foreign public official. But the concrete efficiency of this new set of measures proved to be limited in Europe. Despite the signature of the OECD Convention, European countries failed to impose demanding anti-corruption standards to their local companies. Therefore, the FCPA remained until the year 2010 the only regulation to efficiently fight against international corruption. This context allowed the US to defend its interests and play its role of global policeman through an extraterritorial application of the FCPA. Thanks to the famous Deferred Prosecution Agreement procedure, nicknamed DPA, the DOJ has imposed record sanctions on several European strategic companies. In 2014, Alstom was fined $772 million. Alstom acknowledged that some of its employees had paid bribes up to $75 million to officials in Indonesia, Egypt, Saudi Arabia, the Bahamas, and Taiwan to win contracts for projects valued at $4 billion. If we want European prosecution authorities to be credible partners for the DOJ, the EU and European countries should efficiently sanction by themselves domestic companies committing bribery. In this vein, the United Kingdom adopted the UK Bribery Act in 2010. This law, considered as one of the most stringent anti-corruption laws in the world, came right after the BAE Systems case. In this case, the government of Tony Blair classified the file as national security to prevent prosecution initiated by the Serious Fraud Office against the companies for suspicion of corruption in Saudi Arabia. Afterwards, France has questioned the efficiency of its legislative arsenal in the fight against corruption. US extraterritorial sanctions played an important role in the adoption of December 9, 2016 of the Sapin II law on transparency, fight against corruption, and modernization of economic life. This regulation marked the entry of France into the modern era of compliance, with the aim of bringing it to the level of the best international standards, notably by taking inspiration from the method devised by the US DOJ. First, the Sapin II law created the obligation of implementing compliance programs within French companies and groups whose parent company is headquartered in France exceeding certain thresholds. The anti-corruption agency is in charge of controlling the concrete application of these measures. The agency is essential to ensure the effectiveness of these new instruments over time and to prevent crimes. It is a main difference with the DOJ, which is more in charge to sanction than to prevent. Second, the Sapin II law created the Public Interest Judicial Agreement, the French version of the DPA, which has already been used even time since the 2016. How the conclusions of an agreement impact the prosecutions brought by foreign authorities for the same facts. There are various examples of coordinated resolutions between the French Financial Prosecutor's Office and the DOJ. Since 2018, we observe that the DOJ is more and more willing to conclude coordinated resolutions with European prosecutors' offices. In these cases, the amount of the fine is distributed between the countries involved in the deal. The division of the fine depends on the strength of the ties countries have with the crime. Coordinated resolution are a way to make an efficient application of double jeopardy principle. This progress was made possible by the ability of some European countries to adopt procedures like the American DPA. From now on, the French progress to provide an effective application of the highest anti-corruption standards deserves to be supported by a modern European initiative on compliance. Indeed, to raise European countries to the highest international standards and create a global level playing field, it is necessary for the EU to rapidly strengthen its action in the fight against corruption. The Eurobarometer Institute survey on corruption showed that 43% of Europeans believe the level of corruption in their country is higher than it will be in 2013. Despite this reality, the new European Commission has not considered opportune to make the fight against corruption a priority. None of the 26 mission statements sent by the new president of the European Commission, Mrs. Ursula von der Leyen, to the commissioners appointed by the member states mentioned the fight against corruption as an objective of the new term. That is why the Club des Juristes, the French legal think tank, is about to propose to the EU to adopt the European Compliance Act in order to promote a global level playing field. This global act would have two goals. The first goal is to harmonize the European law on combating bribery. The current anti-corruption European law is too narrowly tailored to impose strong obligations on member states. That is why it is necessary to harmonize the European law on combating bribery. First, by adopting a set of 3 new European directives. A first directive could require member states to comply with the principles and recommendations set out in the OECD Convention. A second directive will have to impose member states to incriminate acts of corruption committed abroad. The aim will be to enable member states to punish corruption offences that affect their territories, even if committed abroad, in order to promote an extraterritorial application of our anti-corruption standards. The third directive should require member states to subject companies meeting certain thresholds to obligations to prevent and detect corruption. Directive could also require member states to designate an authority in charge of monitoring compliance programs, while leaving member states free to choose this authority, which could be administrative or judicial. The second way of harmonization would be to insert anti-corruption clauses in secondary European legislation. Directive of February 26, 2014 on public procurement provides that public contracts should not be awarded to economic operators that have been found guilty of corruption. Such a provision has proved to be very efficient. Then it should be inserted in sectorial secondary European legislation, making the exercise of certain regulated activities, such as banking, investment services, and insurance, subject to authorization. Then, violation of the anti-corruption clause will allow authorities to remove the authorization. Plus, an anti-corruption conditionality clause should be systematically imposed by the EU in new generation economic partnership agreements with third countries. These types of agreement already included human and fundamental rights clauses, providing an anti-corruption clause could allow the EU to withdraw advantage by the advantage to such which would not respect their commitment to fight against corruption. This provision has already been included in 2009 partnership agreement with Indonesia. The current goal of the European Compliance Act will be to improve the cooperation between European states. Indeed, the adoption of an anti-corruption package under European law should be accompanied at the procedural level by a strengthening of cooperation between member states in the fight against transnational corruption. Ultimately, an improved cooperation requires the extension of the competence of the European Public Prosecutor's Office, nicknamed EPO. The EPO was created by the regulation of October 12, 2017, which entered into force on November 20, 2017. The office has just started to work on last September. Its very limited jurisdiction risks to make the EPO very inefficient to lead the fight against corruption in Europe. Indeed, the EPO is not entitled to prosecute crimes committed outside the member states' territories. Plus, its jurisdiction is materially limited to offences affecting the financial interest of the Union. This means that acts of transnational corruption, which do not harm the financial interests of the European Union, are not within the jurisdiction of the EPO. Considering the absence of political consensus to extend the competence of the EPO, the EU and European countries must, in a very short term, find solutions to strengthen their cooperation with existing tools and regulations. Eurojust appears to be the natural authority to play this role. The Treaty of Amsterdam, signed on October 2, 1997, created the European area of freedom, security, and justice. It provides many opportunities of criminal cooperation between member states. Indeed, acts of corruption can now give rise to European investigation orders, the issuance of a European arrest warrant, as well as acts of cooperation within Eurojust or Europol, the European Enforcement Agency. The European area of freedom, security, and justice has led to the creation of Eurojust in 2002 and the adoption of the framework decision on prevention and settlement of conflicts of exercise of jurisdiction in criminal proceedings in 2009. Both should be used in more efficient way. First, Eurojust, so far it has mainly focused on fighting against organized crimes such as fraud, money laundering, drug trafficking, human trafficking, and so on, but very few on the fight against corruption. However, regarding its mission, Eurojust is the most legitimate actor to organize the cooperation between member states on fighting bribery. Indeed, Eurojust's mission shall be to support and strengthen coordination and cooperation between national investigating and prosecuting authorities in relation to serious crime affecting two or more member states. This task includes coordination between the competent judicial authorities of the member states, implementation of international mutual legal assistance requests, and execution of extradition requests. Considering these broad missions, organizing the cooperation between member states to fight against corruption should be the first and foremost purpose of Eurojust. Second, the framework decision of 2009, this text seeks to prevent an infringement of the double jeopardy principle in Europe, meaning situations where the same person is subject to parallel criminal proceedings in different member states in respect of the same facts. There should be direct consultations between competent authorities of the member states. Such cooperation could notably lead in the concentration of the criminal proceedings in one member state. However, there is no effective application of the framework decision. In other words, the cooperation between member states to coordinate which one is the most legitimate to pursue a crime of corruption committed in several territories does not exist so far. Under these conditions, it would undoubtedly be more efficient if cooperation between the member states in the fight against transnational corruption were to be reinforced within Eurojust which constitute the natural framework for resolving conflicts of jurisdiction in law enforcement matters. In summary, if the EU and European countries want to apply themselves at the best anti-corruption standards, they have to carry out a strong initiative to implement a global playing field through harmonization of European legislation and improvement of cooperation between member states. From now on, I give the floor to Astrid Mignon Colombet, who will specifically focus on the negotiated issues and will advocate for the use of negotiated justice mechanism in Europe.
Thank you, Bernard. Ladies and gentlemen, hello from Paris, and thank you for attending this webinar. Thank you again, Bernard, for this presentation. I wanted to start with a likely coincidence, but today the OECD just published the United States Phase 4 report, confirming its leading role in the fight against transnational corruption. So what is most relevant for our discussion today is that the report outlines that the US has increasingly sought to coordinate and cooperate with resolving multi-jurisdictional foreign bribery matters with other jurisdictions. Amongst those jurisdictions, we find European countries. And if we take a look at the top 10 FCPA resolutions, published notably on the FCPA blog, we can see that European companies are among the ones which paid the highest fines. This is already known by all of you. But we know also that it's true that Goldman Sachs has just resolved a foreign bribery case through a DPA and a guilty plea on October 22nd, 2020 for $2.9 billion. Apart from Goldman Sachs, what is interesting and relevant for our discussion today is that 6 companies in the top 10 are European. Airbus, Ericsson, Telia, Siemens, Wimpelcom, Alstom, and Société Générale. This situation, as Bernard said already, is due to many reasons. Historically, it is due to the lack of willingness among European countries to prosecute transnational corruption, and also the absence of stringent compliance standards in most European legislations. However, things are changing in France and elsewhere in Europe. First, in France, Bernard explained it already, we had our Sapin II law in 2017, accompanied by the signature by the French PNF, the French financial prosecutor, of 2 transnational coordinated resolutions, Société Générale in 2018 and Airbus 2020. With these 2 cases, France has undoubtedly demonstrated its strong ability to become an enforcement authority alongside with the other enforcement authorities, contributing to this famous level playing field we're speaking about today. You know it already, the French DPA has already, which is called the Public Interest Judicial Convention, has been used 11 times since 2017. And what is interesting for our discussion today is that we can observe a significant increase of multi-jurisdictional resolutions between prosecutors in Europe and also with the DOJ. And if we go back to 2008, not 28, but 2008, the first multi-jurisdictional case was the Siemens case, a German case. And what is interesting in this case is that with a close coordination with the prosecutor of Munich, the Department of Justice announced the conclusion of this settlement with Siemens, where the financial penalty was divided 50% to the US and 50% to Germany. And most recently, the August case well illustrates this unique coordinated resolution, trilateral resolution between the French PNF, the UK SFO, and the DOJ. And what is noticeable in this case is that the largest part of the amount of the penalty, 58%, was attributed to France, and about more than 27% to the UK, and more than 14% to the US. And what we can see is that the August case illustrates again this emerging theory according to which most of the penalty is allocated to the state whose territorial and personal jurisdiction and also willingness to initiate prosecution is the most obvious. And interestingly enough, the recent increase of multi-jurisdictional resolutions show that the US itself is willing to promote resolution with European countries, countries which have demonstrated their willingness and ability, of course, to prosecute their own companies for offenses they have committed. And moreover, according to the well-known US piling on doctrine, which was developed in 2018 by the Deputy Attorney Rod Rosenstein, the US prosecutors are invited by the Department of Justice to coordinate with other regulators and foreign enforcement authorities seeking to resolve a case with a company for the same conduct in imposing a penalty. But as the piling on expression is clear, that means that DOJ attorneys are invited to take into account the amount of penalties already paid to foreign authorities in order to credit it when calculating the penalty which will be paid by the company to resolve the remaining charges. So what is, again, very interesting to this European discussion we are conducting this evening is that such an empowerment of non-US states to be part of a resolution of multi-jurisdictional cases can contribute to the development of a European transnational negotiated justice. The question at stake here, as Bernard suggested it, is how can we better apply within the European Union the non bis in idem principle, maybe well known as the double jeopardy principle. We know already that international application of the double jeopardy principle is very limited today by virtue of territorial sovereignty principle. The situation is quite similar in Europe, even though we have already European conventions and regulation mechanisms. First, this is true that Article 50 of the Charter of Fundamental Rights of the EU provides the right, specifically, not to be tried nor punished twice in criminal proceedings for the same offense within the Union. However, this provision is addressed to the member states only when they are implementing Union law, which de facto excludes most of the transnational corruption offenses. So we could go to another European convention, which is the Schengen Convention, and Article 54, which provides the same double jeopardy principle. However, a state can declare not being bound by this provision when the offense takes place in whole or in part within the own territory of the prosecuting state. So therefore, we can easily come to the conclusion that per se, the transnational application of a double jeopardy principle is not sufficient in Europe. Consequently, a better solution would be to rely on non-binding cooperation mechanism between member states. We already know regarding OECD member states that Article 4, paragraph 3 of the OECD Convention provides that in case of concurrent prosecutions, states should consult each other with a view to determine which is the most appropriate jurisdiction for prosecution. In practice, despite this non-binding provision, defendants can be subject to subsequent prosecutions and sanctions for the same offense in various countries, and also subject to multiple criminal resolutions. If we take as an example the SBM offshore case, this was a Dutch company with a US subsidiary which was prosecuted for an FCPA case in various countries. Initially, in 2014, the Dutch authorities concluded a resolution by which the Dutch company settled the case with the Dutch prosecution authority for $240 million, while the DOJ declined to prosecute the case. So we thought at that time that it was the first attempt to apply non bis in idem at the early stage of initiation of prosecutions, but that was not true. However, 2 years later, in 2016, the DOJ reopened the investigation on additional information and concluded a DPA with a parent company. And again, 1 year later, the company entered in another agreement with the Brazilian federal prosecutor. So you see, these kinds of non-coordinated resolutions illustrated by those successive settlements make defendants more vulnerable, exposing them to a high degree of uncertainty. This is all the more the case if the countries exposed to successive or multiple prosecutions do not have in their judicial system a DPA-like resolution for criminal offenses. As we described it previously, considering this lack of international conventions on double jeopardy, this increasing tendency to regulate excessive prosecutions, multiple prosecutions, could be done through coordinated settlements. In other words, multi-jurisdictional resolutions could become an informal way to promote the double jeopardy principle. The question is, could we go forward? What could be done specifically in Europe to actively promote the double jeopardy principle between the different member states and promote, therefore, transnational negotiated justice standards? We believe that such a promotion needs a two-step approach tailored to European member states' legal, judicial culture, and judicial systems. First, there's a need, obviously, to increase closest coordination and consensus between the member states in order to avoid multiple prosecutions. And second, we could promote the adoption of DPA-like resolutions in order to harmonize multi-jurisdictional settlements. Regarding closest coordination, we have one framework decision from the European Council in 2009, which is interesting for a matter which is related to prevention and settlement of conflicts over jurisdiction in criminal proceedings. This decision already provides, as Bernard reminded it, a procedure of direct consultations and exchanges of information between different prosecuting authorities of the member states in order to prevent situations where the same person is subject to parallel criminal proceedings in different member states for the same conduct. And the framework decision is explicit on implementing an obligation to contact the other authority and an obligation from the requesting authority to reply. And we understand that the purpose is to reach consensus on any effective solution aimed at avoiding all the adverse consequences arising from such parallel proceedings. And where relevant authorities are not able to reach a consensus, which could be easily imagined, well, the case should be referred to Eurojust, which at the time of the decision had just been strengthened by the Council decision. So we have the tools. The issue is how we can better apply them within the European Union. So one idea is to promote the effectiveness of a framework decision with the European Union, which could detail what are the relevant criteria to determine which prosecuting authority is the most legitimate to prosecute. Of course, each authority strongly believes that they are the most legitimate to prosecute. So we should find and try to define possible criteria where the illegal conduct takes place, where the public order has substantially been impacted by the offense, where the headquarters of the relevant entities are located, and also which jurisdiction initiated the investigation and what were the resources expended by the jurisdiction, the prosecuting jurisdiction. Second solution to promote European negotiated justice. We should think about promoting DPA-like resolution procedures in the member states. I strongly believe that the promotion of DPA-like resolution is crucial to build an efficient regulation of multiple prosecutions. However, only a few countries in Europe, if my understanding is correct, have adopted DPA-like resolutions. We can refer to the OECD report issued in 2019, which provides an interesting analysis of the different DPA-like resolutions, which are defined as a form of non-trial resolution, which consists in a deferral of a prosecution subject to the fulfillment of a specific condition, such as a compliance obligations. But most important for our discussion is that DPA-like resolution does not imply a conviction nor an admission of guilt. So far, to our best knowledge, only France, UK, and Netherlands, they have a DPA-like resolution called a Transatlantic, I don't know if I have a correct spelling, have adopted such DPA-like resolution. In Italy, we have a patteggiamento, which is a hybrid resolution, if I refer to the OECD report, that results in a conviction, but a conviction that is not conditioned upon an admission of guilt. In Germany, you have a resolution which results in an administrative decision imposing sanctions without a formal conviction. So the European Union should actively promote and urge member states to adopt DPA-like mechanism in order to improve this informal transnational coordinated resolution. At that stage, they exist at least one case of European coordinated resolution exclusively between European member states and apparently without any US enforcement dimension. It is the Hempel settlement, which was settled in 2019, March 2019. Coordinated settlement was reached between the Danish manufacturer Hempel and the German Public Prosecutor's Office, and alongside with the Danish Public Prosecutor's Office, to resolve allegations of bribery in Germany for other allegations of bribery which had occurred in other countries in Europe and Asia. Let's hope that this exclusively European coordinated resolution will be the first of many other ones, and that is the sign of a future non-trial resolution standards in Europe. So we thank you very much for your careful attention and would be pleased to answer to your questions, if any.
We are waiting for the questions.
We are waiting for the questions.
This one? Yes, we have a question concerning EPO and the capability for EPO to persecute a certain number of offences. I would like to answer this question with Astrid. You want to begin? Astrid?
Oh, please go ahead.
With a certain number of points. First of all, I think it will be very difficult to be efficient with EPO, even if we have to fight in Europe in order to give more capability of intervention to EPO, and it will be difficult for a certain number of reasons. First reasons, the jurisdiction is timely limited because the EPO will have competence only over crimes committed after November 2017. The jurisdiction is also geographically limited because EPO is the result of a cooperation between the 22 countries out of a total of 28 member states. And secondly, because it is not entitled to prosecute crimes committed outside the member states' territories. And the jurisdiction of the European prosecutors is also materially limited to offences, and you have explained that very precisely in your statement, affecting the financial interest of the Union, resulting in a financial loss of more than 10,000 euros. This means that acts of transnational corruption, which do not harm the financial interests of the European Union, are not within the jurisdiction of the EPO. And there are other elements who could constitute a problem. We would like to give more power to EPO. First, EPO has just been set up, and the EPO structure is not in place today, and it will not be in place before a certain number of months. So I think that it would be more prudent to wait before giving more capability of intervention to IPO. There is also political reasons. We all know that criminal law is a key element of state jurisdiction, so we should be confronted to political problems if we would try to find a consensus, a compromise about this question. And finally, we are also confronted to technical reason, because the extensions of the IPO jurisdiction could only be realized through adoption of a new regulation, which implies strong political willingness, which would be very difficult to reach in the context of today.
Any other questions? Okay, thank you. I had a question of the audience about is there any European framework in order to coordinate parallel investigations in different member states? So maybe I think the questions refer to this European mechanism of joint investigation teams. That we know that such a mechanism was used in the recent resolution of the August case in 2020. Indeed, this was publicly said. The SFO and the French PNF signed this joint agreement of investigation teams in order to establish a coordinated investigation strategy to ensure, in order to better ensure the sharing of relevant information between authorities in accordance with the French blocking statute, and to use this evidence with a view to bringing to conclude settlement agreements. So this is, yes, this is an effective way to coordinate cross-border investigations, and this implies a high level of confidence between each prosecuting authorities. So this is a challenge in Europe that could be developed maybe elsewhere. No?
Another question, which is how can we, France and more widely Europe, ensure that this equal level playing field does not inherit some of the unequal and lopsided characteristic most common with US extraterritorial jurisdiction, namely economic warfare seen in the case of Alstom, BNP, and Société Générale. To be precise, in my opinion, this is a question mainly of political willingness and international context. It is less likely to happen given that many countries already have strong anti-corruption standards in the world. And such extraterritorial legislation could only have existed in the first place because there were no equivalent legislation in the world. Plus, Europe doesn't have the same opportunities that the US, given that our currency is not as strong as the dollar is. So this is, for my own part, I think the context concerning this question. Other questions? No, no more questions. We're waiting for questions. If there are
maybe one last question.
Yes.
If we have, otherwise.
We're waiting for the questions coming from the people who are helping us.
Thank you so
conduct
much.
this webinar.
So
they are given us the questions. So.
Oh, this is a very interesting questions. Well, maybe let's open the discussion. The question is, isn't the impossibility to prosecute physical persons, individuals, within the CGIP the main weakness of the CGIP? If I understand the question is, and it's an interesting question because I did not develop the scope of a DPA-like resolutions. Are they only open to corporations or also to individuals? And should we open it to both corporations and individuals? The question was related to the CGIP, the French DPA-like, and I know that the answer is not the same in all the EU member states. In France, the answer is crystal clear. The CGIP is only open to corporations because the legislator strongly believes that a criminal sanction should be made to an individual. An individual cannot escape from the consequences of his criminal conduct. But we must admit that such a position can lead to very unfair consequences in case of subsequent prosecutions of the individuals, when the employer, the company, has previously signed a DPA. Of course, the DPA is not a conviction, but still the DPA contains a statement of fact which can refer to the conduct of individuals. So when the individuals are subsequently prosecuted, they can be an issue at stake of a fair trial. We have several examples of those issues in Europe. In UK, for example, you had the Tesco case, and in other countries, such as the US, with a Hoskin famous prosecution. So this is what I can tell for this question of on eligibility to the CGIP for individuals. I think that this is one of the hot topics we will have to define in the upcoming years. Any other questions?
Yes, several words perhaps about this question, yes. Because we have to understand that in France, the CGIP is a new tool among all the tools we have in order to prosecute companies who committed offenses, economical offenses. And for a great number of people in France, and especially for the press in France, at the beginning, before the adoption of the Sapin II law, organizing a kind of transaction with a company who had committed such offenses was a way of avoiding the shame of being in front of the judicial institutions, and to have to explain to the people and to the press what happened in this company. It was not the same approach and the same culture that we have in the United States. In the United States, the DPA is a very old story and a tool which existed since been existed since 1977. So if we want in France to open this tool to individuals, we need first of all to organize the acceptation of the tool by the people and by the political institution before organizing such an opportunity for individuals. But I think that it would be a great opportunity to offer for the company the opportunity of the CGIP for all kinds of economical offenses, for example, offences concerning the environmental issues.
It's already the case.
Yes, so that's a good idea.
It's a good point. Extending the scope of a CGIP to certain offences, but as for Europe, we have to be cautious about thinking about the proper offences to extend the CGIP.
There is questions concerning the discussions at political level to get a European compliance framework. Perhaps a few words about these questions, because it's a very important questions for the public opinions in Europe, and of course it will be very difficult to succeed reaching the goal of a European framework, of a European compliance package, if there is not a political willingness in order to overcome all the problems we are confronted to in order to succeed realizing such a European package. First of all, I was very surprised when the new European institutions were elected and designated by the European governments a few months ago, and when the president of the Commission, Ursula von der Leyen, sent to all the commissioners the program for the next years. In this program, we didn't find a word about the fight against corruption. We spoke about the fights against terrorism, the fights against money laundering, and so on, but nothing about the fight against corruption. And I think it's a problem, because we should not be in situation of organizing a concrete and deep level playing field in Europe if we are not in situation of organizing a common process within the internal market in order to share the same rules. And it's very difficult to have an internal market without being able to fight against corruption in all the countries, if we consider that corruption is a kind of a way of avoiding competition between companies and industries in Europe. So it's very important to organize a good level playing field in Europe to have this very strong political willingness. Second point, we have a lot of people in each countries who have serious doubts about the capability of Europe to protect the citizens and to protect democracy in front of criminal organizations, corruption, and so on. So if we are unable to promote such rules in Europe with, once again, a strong political willingness, it will be a problem to organize kind of trust between the citizens and the political institutions. So it's important for the level playing field. It's important for democracy and the link between citizens and political institutions in Europe. It's also very important if we want to prove to the American institutions, especially to the DOJ, that we are in situation to prosecute corruption in our own countries and to be in situation of doing the job we have to do in Europe. If we are unable to prove that, of course, the implementation of US law in Europe will go on. So it's very important to be in situation of being at the best international standards concerning the fight against corruption if we want to convince European prosecutors that we are in situation of doing the job in our own country. So for all these reasons, it's very important to succeed reaching the goal. This afternoon, we were with the European Commissioner Didier Reynders in order to present him what are our proposals concerning the European framework and the European package against corruption. And he was very positive, explaining that it would be difficult to find a compromise between all European nations because they are not in the same approach of the rule of law and not on the same approach about all the issues concerning the fights against criminal organization and corruption. But he considers that we have to find a pragmatic way to go on. And perhaps the best way of going further and overcoming the problems we are confronted to would be to organize more cooperation between the states who want to go further.
I think we have a last question from the audience. Thank you for the question. Coming from somebody in the United States, probably, or the US and the UK have very clearly defined principles on how a fine and disgorgement are calculated. And you asked a question in France, does France have also such clearly defined principles, or is the penalty in France based on negotiations with a company and between the prosecuting authorities? So the answer is yes, we have principles. Are they very clearly defined, like in the US? The answer is not so clear. We have very recently some joint guidelines signed by the PNF and the French Anti-Corruption Agency, who provides guidelines to determine how to calculate the financial penalty in the scope of a CEGIP. There are some methodology explained to calculate the advantage. What we call disgorgement is called in our French vocabulary avantage tiré de l'infraction, which is the equivalent of a gain that you have in the US concept. But you have the PNF guidelines on the one side, you have also this French circular from the Minister of Justice, who tried to explain how we can calculate the methodology to calculate the gain that the company earned from the illicit conduct. And it's not so easy to have this detailed measure of a gain. So how to calculate the gain? Is it the EBE that should be used, or is it the turnover of a company? We have various criteria. And then other question, how can we have a precise definition of what could be the aggravating factors applied to the penalty or the mitigating factor. We have to be simple, and we have 2 minutes left. We have a qualitative approach in France, but we do not have, as in the US, really clear defined principles with to calculate the score of culpability. I hope this answers your questions, and we are happy to answer further if needed. So
I think there are no more questions, and it was for us a great pleasure to share this moment with you and to speak about this very important issue for France and for European nations. And we are, of course, very happy of this moment and ready to speak once again with you if we had the opportunity to organize such a discussion in the future. Thank you so much.
And thank you. We hope that we have the opportunity to meet in person in Paris in next September. That would be great. Thank you for your attention. Bye.